So I'd like to start out by welcoming everyone that's here today. We have a couple of people here that are live and the rest of you out there in internet land. So thanks for joining us. I'm Jennifer Steneberg. I'm one of the attorneys here at the Dale Law Firm, and I'm going to be talking with you a little bit this afternoon about limited conservatorships. I'm going to be joined a little bit later by my paralegal, or one of the paralegals here, Teri Milich, who is going to walk you through some of the procedural stuff. But before she does that, I'm going to go over general information about conservatorships, how they're established, and the purpose, and some of the do's and don'ts. So let's just dive right in. I will have to use the clicker. Hold on. Okay. Things to think about. So when an individual is turning 18 in California, that's a time when families are having to make lots of decisions about the future of their disabled son or daughter or family member. And one of those decisions is whether or not to file for a conservatorship of that person. This usually happens at 18, but not always. Sometimes it is delayed and families can do this later. But 18 is really the period of time when it's coming to the fore because the person's obviously transitioning from childhood into adulthood. When you're considering conservatorship, you really need to balance some competing factors. You're looking at taking your child's ability to make decisions and choices away from them and having that given to another individual, usually a parent, but could be other individuals, to make decisions on their behalf. So obviously this is a big consideration. It's difficult for many families, and the intent of our presentation today is to try and kind of help you understand that decision a little bit better and hopefully give you some information so you can make a better informed decision before you decide which way to proceed. Keeping in mind always that conserving an individual is really limiting their civil rights. This is really a judicial process where the court is taking someone's ability to control their own lives away from them and handing it to another person. And the court does take that quite seriously, as they should. So as I mentioned a minute ago, 18 is kind of the magical age. All persons in California are presumed to be competent or to have capacity when they turn 18 years of age. And this is regardless of any other circumstance or consideration in their lives. I would question myself at 18 as to whether or not I was truly competent, but nonetheless, according to the law, we all are. And in that vein, we're able under the law to then make all of our own financial, medical, and personal decisions. Legal decision-making authority is taken away from a parent by law when the child turns 18. And that happens regardless, as I said, of any circumstances that may be involved in the individual's life. So one of the first things that we have to think about when we're at this juncture is, and considering conserving an individual or looking at alternatives to conservatorship, is whether the individual has what we call legal capacity. And this is really the legal determination that a court would be making if you were to file a petition for conservatorship. One of the things the court must decide is whether or not the individual meets the standard for legal capacity. So here we're providing you with language directly from the statute that says that the mere diagnosis of a mental or physical disorder is not enough to establish that someone lacks capacity. To establish that, it has to be shown to the court through clear and convincing evidence that the person cannot provide for his or her own personal needs. So again, it's really a functional sort of definition, and the court looks at the individual's varying mental functions when making this determination. So here again, the statute tells us that incapacity must be shown through evidence of a deficit in at least one of four mental function areas that either renders the person unable to make or communicate decisions or to understand and appreciate the consequences of their decisions. The four mental function areas that are listed in the statute are there on the slide for you. They include alertness and attention, information processing, thought processes, and ability to modulate mood and affect. Now, Teri's going to talk about this a little later, but the way the court actually receives information and makes the determination about capacity is through one of the forms that's filed with the court called a capacity declaration. And this is actually a form that has to be filled out by a physician, a psychologist, or a psychiatrist that's licensed in California that can provide the court with basically an assessment. And they have to provide an assessment on a kind of a ranked scale in each of these 4 areas. And that's what the court really relies on when making this determination. Now, we often get asked by clients and families when we're doing presentations like this, does everyone with a developmental disability need to be conserved? And obviously, we believe the answer to that is no. We hope that all of you believe that as well. Because clearly there are people who are developmentally disabled that have capacity and can make decisions for themselves and should be allowed to do that and to control the direction of their own lives. They may need some support in doing that, and there's mechanisms that we'll talk about in a minute where you can continue to provide that support. But certainly we don't want to be taking people's individual rights away if it's clearly not appropriate. As I mentioned earlier, the decision as to whether or not someone needs to be conserved, you have to look at their functional ability and needs. And you also need to consider whether they have the capacity to care for themselves as a reasonably prudent person. Now, again, in the law, we love these terms like reasonably prudent. What the heck does that really mean? It's a pretty kind of subjective test, but that's the standard. Considering alternatives to conservatorship is something that we believe everyone should do before proceeding down the road to conserve an individual. And there are a number of alternatives to conservatorship, which again will allow a family to continue to be involved in decision making, but not necessarily limiting the individual's rights to be involved in that process for themselves. So in looking at the various alternatives, and quite honestly, many of these are much less intrusive and less costly than doing a conservatorship, so they're often very appealing to families for that reason as well. But in the area of medical decision making, there are a couple of things that can be done as alternatives. The first is an advanced healthcare directive. Now, many of you may already have an advanced healthcare directive for yourself. It's something that when we're working with our estate planning clients, we require all of them to do. And this is something that can be used for anyone to basically appoint or designate an individual who can make their medical decisions for them if they're incapacitated, and that's when most of us rely on it. But it can also be used to identify an individual or more than one individual to assist with making medical decisions for you, even if you still have full capacity. And so that's what we use with many of our families that we work with as an alternative to conserving an individual. An advanced healthcare directive, I'm going to talk a little bit more about it in a minute, and we'll go over some of the details. A second one in the healthcare area is that the regional center is authorized to make medical decisions for regional center clients who don't have anyone else that can make decisions for them and who have been deemed to not have the capacity to make their own informed medical decisions. So that's another option, and I'll talk about that a little bit more as well in a moment. With regards to the other areas of decision making in one's life, we often use powers of attorney, and these can be very broadly drafted or very narrowly drafted. And then there's also a method under the Lanterman Act where if you want to be involved in the regional center process and there's concerns about that, an individual can become an authorized designee by the regional office of the state council. These used to be the area board. Some of us still commonly refer to them that way, but they're now called the regional offices of the state council, and under the Lanterman Act, they can designate individuals to be part of the IPP team. And then finally, for financial purposes, oftentimes we can use special needs trusts or other forms of trust. That might be a way of assisting and managing finances for an individual who may not be in a position to manage their own financial affairs. Now, a power of attorney just to get into the alternatives a little bit more in depth. A power of attorney is a written instrument which a person uses to designate some other individual to act on their behalf. And again, as I mentioned a moment ago, the powers that you can grant to a person under a power of attorney are virtually limitless. They can be extremely broad and they can cover almost all aspects of your life, or they can be very specific and just include one or two specific areas of decision making or even individual transactions. So they're very flexible documents and they can be nicely tailored to the needs of the individual at hand. We have a power of attorney template that we've kind of developed here for our clients that are developmentally disabled, and it includes areas of decision making with the regional center, dealing with day programs, residential programs, other sorts of community supports, government entities like Medi-Cal, Medicare, Social Security, and the like. So it nicely covers lots of the areas that our families and our clients are usually kind of involved with. A power of attorney is a relatively easy and inexpensive method. It usually just requires the individual meeting with myself or one of the attorneys in the office, and we make a determination on our own that the person does have the capacity to understand the nature of the power of attorney, and then we go through it with them, explain it, they sign it, and it's in place. A power of attorney, however, is a revocable document, which means that if the individual grants you as the parent the authority to make decisions for them in various areas, and then in the future there is a dispute between you and the conservatee, they can always revoke your the person under the power of attorney. They can always revoke the power that they've granted to you because this is a voluntary transfer of authority that they are making. So they can pull that back. Unlike a conservatorship, where that's the court granting you power, and therefore in that case the conservatee would not be able to effectively trump you. Also, it's important to know that a power of attorney terminates upon the individual's death. So it does not allow you to make post-death decisions on behalf of the individual. So it can't be used for, post-death funeral arrangements, that sort of thing. Okay. I mentioned earlier that we can also use advanced healthcare directives for making medical decisions. And again, an advanced healthcare directive is much like a power of attorney. The difference being that here you're appointing an agent to make medical decisions as opposed to financial or other personal types of decisions for you. The advanced directive enables the principal to also express their wishes with regards to end-of-life care, life-sustaining treatment, organ donation, and other types of care issues that they may be concerned with. So it gives them an opportunity to kind of direct how they want decisions made in a very global sense, while at the same time authorizing you to be the person that's actually making the decisions for them and directing their care. Again, like a power of attorney, it's a fairly quick and easy document to get in place. Usually just requires one meeting with someone from our office if you're working with us. Again, just like a power of attorney, it's also revocable at any time by the principal. So again, if you're sitting in a doctor's office with the individual and you have the advanced directive, if there's a decision to be made and the two of you are not in agreement, they're still going to be able to trump you. So while it's giving you power, it's not giving you absolute power. There's also certain things that you're not authorized to do as an agent under an advanced directive. And those are listed here, and they include commitment to or placement in a mental health treatment facility, giving consent for convulsive treatment, psychosurgery, or sterilization. Also includes abortion, mercy killing. As you can see, it's kind of the controversial areas of healthcare that the government doesn't feel that they are in a position to grant you authority to decide. All right, and then again, the other alternative within the medical decision-making realm is this idea of the regional center making decisions for a regional center client. Now again, keep in mind that this is only effective if the individual is a client of the regional center. Now, Most individuals with developmental disabilities are, so it's usually not a difficult threshold to meet, but this alternative is not going to work for someone whose disability does not meet the definition of developmental disability. Under the Lanterman Act expressly, it directs the regional center or the director of the regional center or his or her designee to give consent to medical, dental, or surgical treatment for the client, and to provide for such treatment if the individual has no parent, guardian, or conservator who's legally authorized to consent. So again, in the situation of an adult, a parent doesn't have legal authority any longer because the individual is over 18, so unless the individual is conserved, then this is really the only other option if the person lacks capacity. Although the Lanterman Act doesn't specify who might be qualified to be designated to make medical decisions, and sometimes we have families who will ask, well, can't the regional center designate me to make the decision? I guess under the law they could, but I've never seen them do it. Most likely it's going to be a regional center staff member, and usually it's like the director of health services within the regional center that would be the person actually making the decision. However, I will say that where I've seen this used, that individual does usually work closely and listens to the concerns and desires of the family and will usually work fairly compatibly with the family. But again, keep in mind, they certainly don't have to, and they could trump your decision. Okay. IPP participation, this is actually another area where we often get clients, or not often, I shouldn't say often, we occasionally get clients who will say that the reason they're coming in to talk about conservatorship is because they're having issues with the IPP process in the regional center. And they're fearful that they may be excluded from that process, so they want to make sure, but through conservatorship, that they have legal authority. This is actually, in most cases, kind of a false fear. Because the Lanterman Act provides very good protections for parents to be part of the IPP team, and they in fact can't be excluded except for in the circumstance where the disabled individual, him or herself, is the person saying they don't want their family member to be involved. So the regional center alone or any other member of the IPP team cannot have you excluded from the meeting. Nonetheless, if there are issues that are coming up, you can, as I mentioned earlier, contact the local office of the State Council on Developmental Disabilities, and if they believe that the rights or interests of your family member are not being properly protected in the IPP process, they can appoint you as what's called an authorized representative. And under the Lanterman Act, that authorized representative is entitled to participate in all IPP meetings as well as fair hearings on behalf of that regional center consumer. Okay, so that has kind of given you a flavor for the alternatives. And again, if you were to work with us, we would go through these with you in more detail if it was something that was of interest to you and help you assess whether or not these might be appropriate vehicles for continuing to be involved and having authority with regards to your son or daughter. However, if the alternatives are not the right route to go down and you think that conservatorship is the way that you're kind of headed, we're going to get into the meat of it now and really talk about conservatorships. So in California, we have two basic types of conservatorships, and then within the two types, there's several categories. So I'm going to kind of briefly describe them all so that you know what they are, and then we're really going to focus for much of the rest of the presentation on limited conservatorship of the person. But before I do that, let me explain the difference first between a conservatorship of the person and a conservatorship of the estate. Conservatorship of the person involves decisions that are personal to the individual. So this is things like medical decisions, residential decisions, things with regards to social activities, individuals being involved in the person's life. Decisions with regards to under the conservatorship of the estate area have to do with finances. So when we talk about someone's estate, we mean their personal property, their real estate, their bank accounts, their finances. So for many of the clients that we're working with, conservatorship of the estate is really not the major concern, because a lot of the individuals we work with don't have personal estates of any significant size. They're usually just turning 18, they're not working, they haven't acquired wealth. So we're not really looking at conservatorship of the estate too closely. However, we have recently started applying for those powers on behalf of our clients. We used to do it where we just applied for the conservatorship of the person powers. We're now also requesting the estate powers because there are instances in the future where finances could come up, and if you don't have that financial authority, then it becomes kind of a crisis. An example would be an individual is getting a small settlement from a lawsuit, maybe a few $1,000s for some minor injury that they incurred. No one is really able to negotiate those funds, receive the insurance payout or the settlement proceeds, and effectively be able to deal with that. And so we occasionally will have clients that will call us in that circumstance, and then we have to rush into court and kind of get an emergency conservatorship of the estate in place so that we can handle that transaction. It's a legal hassle, it's expensive to do it, so we might as well get it all up front so that you have it if you need it. If you never need the power, no harm, no foul. At the same time, we also will request that the court waive the normal oversight that's in place for conservators of the estate so that you're not burdened with having to periodically report to the court about an estate that really doesn't exist. But we are getting that power in place for our clients currently. Now, conservatorship of the person, again, as I mentioned, has to do much more with all of the other things that we think of when we're thinking about how we're going to need to continue to assist our family member. Now, within conservatorship, there's these other categories that are listed here. We have general conservatorship of the person, limited conservatorship of the person, and what's called an LPS conservatorship. Again, we're talking about limited conservatorship of the person today. That is the type of conservatorship that the state has authorized for an individual with a developmental disability. A general conservatorship, on the other hand, is the type of conservatorship that we would be applying for if the person that was being conserved had a mental health disability or was elderly and was starting to suffer from dementia type issues, Alzheimer's, things of that nature. Disabilities that affect a person's cognitive functioning but isn't considered a developmental disability under the definition that we're all used to. An LPS conservatorship is a type of conservatorship that is used for people with severe mental illness where they need to be confined to a locked psychiatric facility. These are usually individuals who have been in the 5150 process, and this can only be instituted by the government, the county in which the individual resides, and they are the ones that have to apply for this status. So this isn't something that can be applied for by a family member, and so we don't run across it too often. Okay, the history of limited conservatorships. So as I mentioned a minute ago, we have this thing called a general conservatorship, and that up until the early 70s was pretty much what we had, and that covered everyone. It was not a very rigorous process, and there was very little due process, court protections, that were in place to protect a person from being conserved. So decisions about the person were often being made by professionals with very little oversight, very little input from families, and people were basically just kind of considered the term wards of the state that we all used to hear. And so it became concerning, and in the early 70s, a number of family members started to get involved in advocacy and felt that we needed to start a new system to provide for better legal protections for individuals with disabilities. The Lanterman Act was being put in place at that time and was running parallel to this sort of movement, and so that's why we see a lot of overlap between our probate code provisions that deal with limited conservatorship and some of the Lanterman Act provisions. The idea was that it was going to shift decision making away from the professional community and put it into the hands of family, who was felt would be in a better position to advocate for the needs of the individual family member. And it also allowed for a scope of power which was much more flexible and customizable, if that's a word, to the individual. So it was better able to match the actual needs rather than it kind of being a blanket all or nothing process, which is how the general conservatorship process still works to this day. Okay, a limited conservatorship, as we've mentioned previously, is a judicial proceeding for persons whose developmental disability substantially impairs their ability to care for themselves or their property. So again, we go back to this concept that not everyone with a diagnosed developmental disability really falls within the scope of the conservatorship statutes. It has to be a substantial impairment that we're looking at. Limited conservatorships are intended to be used only as necessary to promote and protect the well-being of the conservatee, and they shall be ordered only to the extent necessitated by the individual's proven mental and adaptive limitations. So again, we kind of go back to this assessment of the individual's functional abilities. The limited conservatee is not to be presumed incompetent just because they have fallen within the limited conservatorship. They retain all of their individual rights except those that the court specifically takes away through the process. So again, this goes back to the idea that we can be very flexible in how we approach this. If we have an individual who perhaps just needs assistance with making informed medical decisions, but is able to make other less involved decisions about their lives, we can tailor the conservatorship to meet that. So that again kind of goes to that idea. The limited conservator oversees the care, custody, and control of the conservatee, and again, it's subject to limitations that can be ordered by the court. So, and we do use this upon occasion where we can get very creative in crafting the conservatorship order and actually put some very specific limitations or restrictions on how the conservatorship can be used and how the rights are shared between the individual and the conservator. Now, I keep mentioning that under state law, limited conservatorships are intended for a person with a developmental disability. So I think most of us have an idea of what that means, but under the law, it expressly says that for a person to qualify as being developmentally disabled, the disability has to have originated before the age of 18, which is a little bit different than the regional centers' age limit. Their age limit is higher, so if it's a disability that results from an injury like a traumatic brain injury, there can be some distinction here between the state, the probate code's definition and the regional center under the Lanterman Act's definition. The disability has to be expected to continue indefinitely. So again, we're not talking about a short-term disability. It's something that's more permanent in its nature. It has to constitute a substantial handicap, again, something that's not less severe where the person still has functional ability. And it includes intellectual disability, cerebral palsy, epilepsy, autism, or any handicapping condition found to be closely related to intellectual disability. The state has attempted to upgrade their language recently, but they still got the word handicapping in there, so we're going to have to continue to work on this definition. And then again, just to reiterate, it can't be a disability that's solely physical in nature. And there's a little bit of a conflict here because if you look at the list above, you could actually have somebody with one of the expressed disabilities that could in fact just have a physical disability at the same time. For instance, a person with cerebral palsy may have full cognitive functioning but has a significant physical disability. So again, you always have to look at the cognitive and the functional ability of the individual. Okay, I mentioned earlier that we can customize the powers that are available to a limited conservator of the person. So I'm going to go through, there's 7 general areas of power that the court can grant you, and again, keep in mind, even within these powers, if we needed to, we could further limit them. But the first one is the power to select the residence of the limited conservatee. And this encompasses not just the physical location where the person will live, but also with whom they will live, and if they are living in a group home situation, you can choose the agency that's providing the supports in the residence and that sort of thing. It's pretty much anything to do with the person's living environment. There's access to confidential information, records, papers. This is kind of just the disclosure power. It enables you to get access to the information that you're going to need to be able to make an informed decision on behalf of the conservatee. I would note that this doesn't cover it does cover medical records and information. So if you are dealing with medical professionals, you can use this power to get access to information under the HIPAA restrictions. There's the consent to withhold, the consent or to withhold consent for marriage. And this one is sometimes controversial, although not often, but occasionally we will see that this is something that comes up during the court hearings and in the court process. And as we're going to talk about in a little bit, the regional center is involved in this process as well, and sometimes this is something that they will recommend against giving to the conservator. There's the right of the limited conservatee to contract. So for some families we work with, this one is important because they're concerned about their son or daughter being kind of taken advantage of by unscrupulous business people. This gives you the right as the conservator to enter contracts, and it can take away the right of the conservatee to contract for themselves. Clearly in California, if a person doesn't have capacity to enter into a binding contract, then the right or the contract can be deemed null and void. So you would have that power here to be able to undo bad contracts. Medical decisions. So again, this is probably the number one concern for families that we work with, and this gives you, as I mentioned earlier, almost full authority to make all medical decisions on behalf of the conservatee. And that goes beyond just the typical medical. It includes, dental, surgical, some mental health, although it's limited in the mental health area, as we'll see in a minute. Control of social and sexual relationships. Now, I mentioned earlier that the marriage power is sometimes controversial. You can imagine this one would be in that same arena. Again, here is one of the powers where we occasionally will get some pushback, sometimes from the court, sometimes from the regional center if we've requested it on behalf of the family. It really comes down to a number of factors. One, the regional center's position will carry some weight, although perhaps not a lot of weight with the court, but the court-appointed attorney's position on this power can also be very persuasive to the court. So it's usually not a big deal, and we'll talk about it more individually with clients if it's a concern for them. And I would say it doesn't come up at all as an issue in more than perhaps 20-25% of our cases. Decisions concerning education is the final one, and again, this power is a little broader than it may at first seem. It does include education, dealing with a school system, colleges, things like that, but it's also interpreted more broadly to include, again, the regional center, day programs, ongoing community supports would fall within this area of authority that you're being granted by the court. So those are the 7 general areas of power. Okay. Now, there's certain things that you cannot do as a conservator, so there's certain powers that are restricted by the court automatically. These are somewhat similar to the ones I mentioned earlier with regards to the Advanced Healthcare Directive, and they include not being able to give consent to commitment to a locked psychiatric facility. Again, that would require an LPS conservatorship, which can only be initiated by the county. You cannot give consent for treatment with experimental drugs. You cannot give consent for electroshock or convulsive therapy. No sterilization without special court permission. There is an entirely separate court proceeding that you would have to go through to try and get that power, and we've never seen it be successful in all of the years that we've been working in this area, so we don't recommend that our clients ever do it. Okay, who can establish a limited conservatorship? So we've spent now a while talking about kind of what the powers are and how it all works. But the question often comes up, who can be a conservator? There's a preference system that's set up in the probate code, which kind of gives priority to certain individuals. So the spouse or the domestic partner of the proposed conservatee always has the highest preference. They're number one on the list. Next comes relatives, with immediate relatives obviously getting the next highest consideration. I would say that with the clients that we work with, probably 98% of the time, or maybe even higher, we're working directly with parents who are filing conservatorship on behalf of a child. So that's certainly what the court is used to seeing. And you're certainly going to get almost the highest level of preference from the court. When I say preference, that would only come into play in a circumstance where maybe there's competing petitions for conservatorship. And sometimes that happens where we have divorced parents. Each parent might individually be applying. There can be some conflict. Sometimes we have grandparents that will get involved. But hopefully your family situation is such that we're all working cooperatively and we're not going to run into that problem. Conservators can also be an interested public officer or employee of a public agency within California. On rare occasions, the Department of Developmental Services will apply for a limited conservator status for a regional center client. It doesn't happen very often, but I have seen it on a couple of rare instances. So they would fall into this category. There can also be a public guardian, which is a county by county office, and each county has an office of public guardian. And again, they can petition to be appointed, and sometimes they're brought in cases where the court is concerned that either the family is not acting appropriately as the conservator, or sometimes if we have a conservator that passes away and there's no other obvious family member to step into the role, the public guardian's office will be asked to take on that activity. And then it could also be any other person or friend of the proposed conservatee. So virtually, it can be anybody in the state of California over the age of 18, if you really wanted to get down to it. But usually the court's going to insist that there be some connection between the person applying for the conservatorship and the conservatee. Now, who can be conservator and who should be conservator are two different concerns. So who should be a conservator is someone who lives nearby. I mean, that's kind of an obvious. You need to have contact with the conservatee, be physically in proximity so that you are regularly seeing them and monitoring their well-being and so forth. Someone that the conservatee likes and trusts. Obviously, you have to have a good relationship with the conservatee, and it's not going to work if you and the conservatee are contentious or don't get along. Although, we don't always get along with our parents, but that one seems to work nonetheless. Someone with mature judgment and experience. So again, we want someone that's going to make good, sound, common sense decisions on behalf of the conservatee. Someone who maybe has a history of poor decision making on their own part, maybe is not going to make the best conservator. Again, it can be parents, siblings, other relatives, or professionals, as we mentioned in the previous slide. And then again, we mentioned that it could be a public guardian if there's no one else really involved in the conservatee's life. We also often get asked about co-conservators and whether that's appropriate, and the answer is always yes. I mean, most frequently we are actually applying for co-conservators to be appointed. So when you've got co-conservators, that would be more than one person at a time. It can be more than two, but most often it's two with the parents. So two conservators, when they're appointed by the court, they have to make decisions by consensus. In other words, they both have to agree with regards to the decision that's being made in order for the decision or the action to be taken. If you've got multiple, more than two conservators appointed, then it's going to be a majority rule situation. Now, it's not too often that we see large groups, and in fact, we usually counsel against that if a family comes in and says, we've got 5 or 6 people that we all want to have appointed, because, ruling someone's life by committee can become very cumbersome. But we frequently will have parents that will want to have a sibling join as a third co-conservator. And, that makes some sense, because there you're planning for a nice, smooth transition as the parents begin to age, maybe have their own life issues. that they're dealing with, it makes sense to start transitioning some of that authority to siblings or other family members. So it's not uncommon for us to have a group of 3 co-conservators that we're working to have appointed. But again, technically in that situation, you have to have 3 individuals that are going to work together. Under the law, it actually does require that when there's 3, they all have to consent to the decision or to the action. I will tell you, however, on a practical level, that rarely actually happens. I serve as a co-conservator for my sister with my father, and we unilaterally make decisions for her regularly, and it's never called into question. I go with her to her appointments with Kaiser. They look to me to make her decisions, and they don't require that my dad schlep along with us to each and every appointment. So on a practical level, it's not as bad as it sounds, but occasionally it will require that the entire group work in concert. One of the co-conservators, if one of the co-conservators becomes unable to act, again, the other remaining conservators can continue to act on behalf of the individual without you needing to run into court and do something in a crisis situation, which again is why we often advocate for siblings or others to be involved, so that again we have that transition. Eventually, and through some of the processes that my colleague Teri will talk about in a moment or two, there is a process where you do need to let the court know about those changed circumstances, but it doesn't usually have to be done in an urgent crisis mode sort of proceeding. Okay, when to apply. So we talked about 18 at the beginning of the presentation, saying that 18 is usually the most common time when we're considering, but it doesn't have to be at 18. You can apply for conservatorship for an individual at any point in their lives from 18 through death. And we occasionally will have clients that will come in and we'll work on conserving someone that's in their 40s, 50s, 60s. I think the oldest that we've ever had was maybe in their 70s. But, you know, it used to be common that families would just continue to provide care for their disabled family member without any real involvement of the court, and a lot of times they just never got questioned or challenged on it, and people would just kind of look to the family because it was obvious that the person can't, you know, make or direct their own decisions. And that's become more difficult over the last couple of decades, largely because of the changes in the healthcare system, the HIPAA requirements, and the medical privacy rules that are now in place. Medical professionals now really do look to making sure you have proper legal authority. So we're seeing typically these conservatorships be instituted much earlier and at 18, but again, it doesn't have to be that way. However, you really can't apply for a conservatorship too much before the 18th birthday, because you're going to get pushback from the court if you do that. So usually what we recommend is that you start working with our office or another law firm that's going to assist you with this about 4 to 6 months prior to the 18th birthday. That gives us ample time to put together all of the necessary paperwork that has to be compiled and get it filed with the court, with the idea of having the court hearing scheduled around about the person's birthday. If it's a few days before, that's fine. If it's a few days after, that's usually not a problem either. But we want to try and get it as close to 18 as we can, so that there's not a lapse in time. If you get the hearing close to 18, then you're not going to have a situation where you might have something come up and not have the legal authority to act on behalf of your family member. So again, ideally the best time to start working on this is about 4 to 6 months before the 18th birthday. So, okay, now we're going to change modes a little bit. We're going to change people. Teri Milich, the paralegal that I work with on our conservatorship cases, is going to step into the booth here, and she's going to talk to you for a little bit about the process itself and kind of what we have to go through to get the conservatorship in place. So I'm going to sit here quietly for a moment so Steve can edit, and now I'm going to get up and move.
Just reposition. Oh. Wait. I think we're good.
Hi, I'd like to begin by breaking down the process a little to make it more understandable. our first segment will be preparing the documents and then filing the petition. The preparation of all the documents is what I will do, and I will pull all the information from you and add it to all these documents. After that's completed, then Jennifer will review them, and if they're all good to go, I will forward them to you for signature, and then you'll come back to me with the signature pages, and we will then file them with the court and get a hearing date. You will then not have a whole lot to do, neither will our office. Mostly the court takes over at that point. The court investigator will get involved. The public defender or court-appointed attorney will also. And also the regional center will do an assessment and file that with the court. And at that point then, when all that's done and we're ready for the hearing, you'll meet with Jennifer and you'll have the hearing. Everything will go great. And we will then go on to our post tasks. Now this can really vary substantially from county to county, and we will review with you what to expect. Some counties, you're good to go and you won't have to worry until the court investigator comes around every 1 or 2 years to do a quick little review. Others, you'll have to file some documents. So to initiate the legal proceedings to establish it, someone must file a petition with the court where the proposed conservatee resides. The petition document is accompanied by a number of other documents. This can be anywhere from 14, 15 documents, again, depending upon the county we're using. Now we're here with the conservatorship questionnaire, and this is where I come in and where this point is very important. The more thorough you are with completing this questionnaire, the easier my job is and the faster it is, which means that the cost will go down for you. So every blank that's there does need to be filled in. And if you have questions, always call me. This is the first page. It will ask for the conservatee's information. Where, as you can see, we will need to know benefits, if they're on benefits, if they have bank account, and I think everything else is pretty self-explanatory on that one. This next page is for the medical information. This is very important. We'll need the doctor's name, address, and phone number. We'd like you to fill in all the underlying disabilities. And the next portion for personal information is important too. This is where I pull a lot of information for one of the documents that stays confidential. We want to let the court know, we want the judge to be able to read a little synopsis of your loved one. They like to know what their hobbies are, what they do in their spare time, even abilities, and definitely social activities too. This page is for the education and regional center information. So we'd like to get the case manager that is taking care of your loved one. We like to know all the social services that they are involved in. We like to know their school, because we do need that information too. Now we will ask you to always provide the most recent IEP and also the most recent full IPP. Now I know the regional center will give you addendums for a couple years and then do a full-on report. We need the most current full-on report because I do pull a lot of information from that. And then this is for you. This is your information, and for all conservators. So as you can see, we need your typical name, address, work address, but we also must have your social security number and your driver's license number. This is important because the document that I'll draft from this will go to the court investigator. Now this document will remain confidential, so not anyone can go into court and look this up. It remains confidential. And the court investigator will use all this information to do a mini investigation of you. This page here is actually for noticing. Now, we'll want, of course, parents' name and address, but if you've already filled it out in the conservator part, you don't have to fill it out again. But we do need the paternal and maternal grandparents. We need their names and addresses. If they're deceased, we still need their names because the court requires this. We also need siblings' names and addresses. And we like for you to indicate in their area whether they're over 12. If they're 12 and over, they will also get noticed on the petition and the notice of hearing. These are documents mailed to everyone. But if they're under 12, we won't have to notice them. This is contact information for friends and neighbors. A lot of the counties like to have some information like this. Some don't ask for it at all. But again, in this case, we'll let you know which ones do if the county that you're using requires this information. Then we get down to the powers that you would like. Now, a lot of times our clients don't know until the first meeting with Jennifer whether they want all 7 powers or not. And that's a real discussion to have with her. So if you're unsure, just put a question mark on it and we'll know that Jennifer will need to review that with you. The last little sentence there is for voting. The court takes this very seriously. They do not want to remove someone's voting rights if they are capable of voting. And what you have to think of is, can they fill out a voter registration? Can they fill out their name and their address and know that? So that's what that's for. We also have questions here at the top for you to review. Many times clients fill this in with, yes, we do want that specific power. The final thing there is for the person to serve the conservatee. The conservatee has to be served in person. Now, you will have a copy of the petition and a copy of the notice, and you'll have to hand it to the conservatee. If the conservatee throws it on the floor, we don't care. But you will have to fill out a proof of service to say the time and the date that you served them. The court takes this very seriously. Upon receipt of your completed questionnaire, then you will be scheduled to meet with Jennifer, who will review everything with you, answer any questions that you may have, and then it's your decision whether you want to engage the Dell Law Firm to help you with this task. When preparing and filing the petition, this is where the paralegal staff does this, and we do all the documents, and Jennifer, of course, reviews everything, and we'll file all these documents with the court. There are a few of the documents here. The petition, of course, is very important. It's a lengthy document telling the court all kinds of information regarding you, and especially regarding the proposed conservatee. There's a confidential conservatee information. That's the one where I mentioned earlier that I need a lot of information to tell the court a small synopsis of your child. The capacity declaration is the document that will be given to the doctor. We will fill out a portion of it, and then we ask that you personally deliver this to the doctor. What we have found in the past is if we mail it to the doctor, it gets put on a stack of papers and doesn't get completed. So it's a good time to make an appointment with the doctor, take your loved one in with you, and have the doctor, if possible, fill it out while you're right there in the room, because sometimes the doctors even like to ask you questions. The next documents will be the conservator screening forms. Again, that's the form that we'll put your personal information on for the court investigator. We also are doing, which is fairly new, a fee waiver request and order. it used to be that we could not waive all the fees, and one of the largest fee really that you'll face is the filing fee. And the filing fee is anywhere from $435 to even over $500 in San Francisco County. So we asked the court to waive these fees based upon the conservatee's ability to pay the fee. And most all the time, this is granted. The citation is the document that the server will serve on the conservatee. The notice of hearing is important. That goes out to all the people that need to be noticed, which is siblings, grandparents, and mom and dad, and the regional center, court investigator, public defender, or court-appointed counsel. The last document there is the notice of conservatee's rights. And this is the very last document that gets filed with the court right after the hearing. In this document, it lets everyone know, lets everyone know on the service list that the conservatee still holds rights of their own. For example, they have the right to be represented by counsel. And there are other rights too, and Jennifer will review that with you. After the documents are prepared and reviewed, they're sent to you for signing, like we talked about. The package will then be filed with the court, and we will get a hearing date from the court. Now, what we always like to ask you, is there a certain day of the week that's better for you, or is there a day that we need to avoid? Monday, Wednesday, whatever date that is, it's helpful. When we go to file everything with the court does try to set the date to accommodate you. The notice of hearing and petition will be served on all the parties. We talked about that, all siblings and grandparents, etc. And the citation is again personally served on the conservatee. And I believe, am I going to go through this one, the court review and investigation? I can.
Go for it.
Go for it. Once the petition's filed and the court assigns the case to an investigator, that is a court employee, the investigator is going to review if the petition is technically compliant with all the law. They will perform a background check on all the proposed conservators. They will, in addition, interview the conservatee and the conservators. Now, sometimes the court investigator will show up at the conservatee's day program, or sometimes they will make arrangements to meet the conservatee at home. We never know, so be prepared. The court investigator will do a prepared written report to the court, and of course the judge definitely reviews this one closely, and you will get a copy of this too before the hearing. Now I pass it on to you. Thanks.
Okay, I'm back.
It got shorter.
I got short.
Okay, 2 seconds.
Okay. So Teri walked you through the court investigation process, and there's a couple of other folks that are also going to get involved after we file the paperwork with the court. So in addition to the court investigator being appointed, the court will also appoint an attorney to represent your son or daughter, the proposed conservatee. Now, depending on the county, this court-appointed attorney might be the public defender's office. For instance, they do use the public defenders in Alameda County as well as in Sonoma and a few of the others. So if you're in those counties, you'll be working with a public defender. In other counties, they're private attorneys that volunteer to be on the court-appointed attorney kind of list. They're randomly selected. We don't have any way to control who that attorney might be for you. But for the most part, they're going to be probate attorneys like myself who are experienced in conservatorships, and they again have volunteered to serve this function for the court. The court-appointed attorney is going to interview the conservatee. That's their client. So they're going to want to meet with the conservatee, sit down with that individual, and to the extent they can, talk with the individual about the conservatorship application, what you've requested as far as the powers, and to the extent that they can communicate back to their attorney the position of the conservatee with regards to this whole process. It's the job of the court-appointed attorney to let the court know what the conservatee's position is, and to voice that on behalf of the conservatee. The court-appointed attorney will also usually have kind of a more informal conversation with you as the parent, and obviously they're going to be respectful and give you an opportunity to ask them questions and so forth. But keeping in mind that their job is to represent your son or daughter in what is considered an adversarial process, and so they're not going to really be too forthcoming with information, and they certainly aren't going to be able to divulge to you the conversation that they've had with your son or daughter. But this is an opportunity for you to request, if it's desired and if it's appropriate, to have your son or daughter's appearance at the hearing waived. And for some of our clients, this is more concerning than others. Sometimes we have clients whose behaviors are such that it's either disturbing to the client or disturbing to the court for them to be physically present at the hearing. We certainly don't want to put them in a situation that either puts them at risk or in which they're uncomfortable or are going to experience extreme anxiety. So usually the attorneys are pretty helpful in this, and they're pretty willing to waive their client's appearance at the hearing if it's appropriate. So don't feel bad about having that conversation with them. So the court-appointed attorney also will sometimes prepare a written statement for the court prior to the hearing and file it with the court, and if that is the case, then they will serve us with a copy as well as you, so we again will know what their position is prior to the hearing itself. Although sometimes, and certainly in some courts, the preference is that they not prepare a written report, but they just appear at the hearing on behalf of your son or daughter, and then they will verbally just advise the court as to their position or their client's position with regards to the conservatorship. 9 times out of 10, what this really said, they get up and they say, Your Honor, I've met with my client, I've met with the family, and it's a wonderful situation, and I'm in full support of the petition. Rarely is it an adversarial, proceeding. But occasionally there will be some back and forth, again, perhaps over 1 or 2 of the powers that you've requested. Okay, and then finally, the court's also going to request an assessment from the regional center. And we've kind of made passing reference to this earlier in the presentation, but the regional center is required under the probate code to review all limited conservatorship applications. And usually what that consists of is your case manager or their supervisor or the IPP team members will get together and they will write a written assessment that provides kind of a brief narrative, again, of their perspective of the conservatee, who they are, the types of programs that they're involved in, a little bit of background about them. And then they're going to go through the conservatorship petition power by power and make a recommendation with regards to each of the powers that you've requested. And again, I would say most commonly what we see is that they will recommend, if you've requested all 7 powers, they usually are in favor of 5 of the 7, and probably about, 30 to 40% of the time, they're going to be in favor of all of the 7 powers. And again, their written report is provided to the court ahead of time, and copies are served on all of the parties. So again, we know in advance what their position is. Okay, so after everyone's given their input, we all are going to show up on the day of the assigned hearing. As Teri mentioned, I will meet with you at the courthouse. Typically, we ask you to be there about 15 minutes before the calendar time so that we're not running in the door late. And it's always very anxiety provoking for everyone when we're late. But nonetheless, once we get there, we probably still are going to have to sit around for a little while because you're going to be on a calendar that's going to have a number of other matters on it as well. We never know if we're going to get called first, 10th, or 20th. It's just kind of the luck of the draw once you get there. So once the case is actually called by the court, we all go up to the front and we stand in front of the bench. The judge is there in his or her robes. But it's nothing like TV. It's very informal. They're very friendly. And usually they'll have a brief back and forth with the court-appointed attorney first. They'll then usually turn and look to me and ask if I have anything I want to add. And what you want me to say is no, Your Honor. Because if I have to say anything, that means there's something for us to discuss still. So usually I just say, no, Your Honor, everything seems to be in order, and the judge will say, fine, that I'm approving the petition. He or she signs the order, and we all sit back down. At that point, you as the client are actually free to go. I, as the attorney, have to stick around for a bit longer. The judge will pass the signed order to the courtroom clerk. He or she usually has to do a little bit of paperwork shuffling, and then eventually the order is brought to me by the bailiff. Once I have that in hand, I can then go downstairs to the clerk's office or across the hall to the clerk's office, depending on where we are, and I'll do all of the paperwork processing with the clerk. But again, you guys don't have to hang out in the courthouse with me while I'm doing all of that. You are pretty much done at that point. I always tell people ahead of time that it's going to be the least impressive court proceeding that you'll ever experience. No one ever believes me. And then when it's all over, everyone always says, really, that's it? And I go, yep, that's it. So trust me, it's not that impressive. As I mentioned, after the hearing, I'll process the letters through the clerk's office, and as part of that, I will secure what we call letters of conservatorship. This is the actual document that you will then use going forward whenever you have to show someone your status as conservator. We usually will get you at least one, sometimes two certified copies of these letters. That's the nice copy with the big blue stamp. Sometimes it's embossed from the clerk. And occasionally, although rarely, you will be told by someone that they need a certified copy of the letters, and that's why we get you one or two. We then advise you to make as many photocopies of that certified copy as you want, and you can freely pass those out to individuals and give them to people. But be somewhat miserly with the certified copies. Keep those for yourself, because if you have to give them away and we have to get more, then we have to go back to the clerk. They usually have to pull the file from the records department. It can take, it can take a couple of days sometimes to secure them, and it's just kind of a hassle. So, so don't just give them away willy-nilly. Once I come back to the office after the hearing, Teri will mail those certified copies to you. She will also at the same time process the order that the court has signed and will serve a copy of that court order, again, on all of the interested parties. So that gets served on siblings, grandparents, the regional center. Everyone that's been involved in the process will get a copy of the order. Okay, then we've got some post-hearing tasks. So these are things that happen after you've been appointed. For the most part, the bulk of the work is done the day or a day or two after the hearing is over. Once Teri has mailed out the order to everyone and sent you your letters, we're kind of in rest mode, so to speak. But there are a few things that need to happen. In some counties, but not all counties, the conservators are then required to complete and file what's called a general plan. This is basically a document that describes the conservator's intentions with regards to the care and supports that are going to be provided to the conservatee. Much of this is just reiterating some of the stuff that's already been put in the petition. It's going to say, the conservatee is going to continue to live at home with his or her parents for the indefinite future. The person goes to this day program. It's just kind of the day-to-day info about the conservatee. The court at the hearing that we all attend will set a deadline for the filing of the general plan. It's usually about 4 months. I think it's about 4 months from the date of the hearing. They give you plenty of time to do it. And Teri will help you prepare that document. In fact, in a lot of cases, she kind of pre-prepares it for you to the extent she can, and then gives it to me, and I'll actually give it to you the day of the hearing for you to finish completing and then sign it. You can either file it yourself if you choose to do that. It just needs to be filed in the clerk's office in the county where the conservatorship is established, or if you want, you can send it back to our office and Teri will file it on your behalf. However, if you don't do it and it doesn't get filed timely, and this doesn't happen often, but our lives are sometimes busy and things fall through the cracks, and we will try to remind you if we know that it hasn't been filed. Teri checks periodically to make sure that you've done it. If it's not been done, she'll call you ahead of time to remind you. But if it still doesn't happen by the deadline that the court has given us, we have to show back up in court and explain to the judge why you haven't filed it. So do your homework and file it, because clients get really unhappy when they have to pay me money to go to court for something like that. So we try to avoid it whenever we can. Okay, there's another document that is also required, again, by some of the counties, but not all of the counties. So depending on where you live, you may or may not also need to file what's called a status report. This is a document that's just used to periodically update the court on changes with regards to the conservatee situation. And the court usually requires that you file this after the first year of the conservatorship. So about a year after the appointment hearing, they will set a date for you to file the status report. And again, if you fail to timely file it, then we all have to run into the courthouse and say we're sorry to the judge and explain why it wasn't done. And then that status report will again be required every couple of years thereafter. And usually what happens in most cases is the court will send you the report to fill out and complete and return and have filed every couple of years. In some counties, they don't proactively do that. They don't kind of remind you, but you will get notice each time you file one as to when the next one will be due. And Teri can monitor that if you choose to keep us engaged, and she'll monitor it and make sure that you get reminders to make sure that you do it in a timely manner. Okay, last but not least, we have the issue of fees. So the bad news is that the attorney's fees for establishing a limited conservatorship, if you were to hire our office to do it, are typically going to run between $3,500 and $4,500. Now that covers all of our fees from start to finish. And when I say finish, I pretty much mean up through the hearing and all of the first post-hearing tasks that we mentioned about mailing out the order, the letters, and all of that. At that point, we kind of figure the scope of our services are done. The court fees, as Teri mentioned, in most cases will be waived. We, again, will file in almost all cases. We will file the waiver request, or they're actually usually deferred, not waived, but it's the same thing in essence. And that will happen as long as the conservatee has limited income and assets. Now, the exception to the rule is if the conservatee has a funded special needs trust. We do have to disclose that to the court as part of the process, and the court pretty much figures, well, if there's money sitting out there in a special needs trust, then they can afford to pay the fees. So they'll usually refuse to waive in that circumstance, unless of course the trust is very, very, very small in its funding. A few $1,000s is not going to prompt them, but if it's much more than that, they're probably not going to waive the fees. Okay. Now, I also mentioned a moment ago that after the initial appointment and before we really get into those last two post-hearing tasks, the general plan and the status report, there's an opportunity for you to basically disengage the Dale Law Firm if you choose to at that point. Some people choose to because they feel comfortable handling those post-hearing tasks themselves, the filing of the general plan, the filing of those periodic status reports. And if that's the case, then we're discharged and you're not going to incur any additional fees from us. However, if you do choose to keep us engaged, and we're more than happy to stay on, then anytime there's any communications back and forth between you and the court, we will be noticed as well. And in addition, we will, of course, monitor all of the compliance deadlines that you have in your case, and we'll remind you of, when those status reports are going to be due, when the general plan is due, and that sort of thing. And again, Teri will always be available to assist you with the filing of those documents. So again, that's a choice that you can make at that time. Teri, again, at the end of the process, will also kind of let you know that you have this option. And if you do choose to go pro per, is what we call it, when you represent yourself, then we'll send you the appropriate document for you to sign that disengages us. We file that with the court, and then you're on your own from that point forward. So, okay. So that brings us to the conclusion of our formal presentation. I'm not sure if Steve's got any online questions for us, or if any of the folks here in the room have any particular questions they want to ask, but now is your chance.
Hold on a second. You're happy there.
Oh, I can sit there.
Yeah,
Here, grab a stool.
Yeah, grab a stool.
If Jennifer's with me, I'll be fine.
Yeah, Jennifer's with you. As long as Jennifer's there, everything's fine. Okay.
We have to get cozy, so we're both
There
in
we
the
go.
frame.
There we go. There we go. See, that's how a paralegal and attorney should. Okay, one minute. Oh, we hit another button. Oh, I'm sorry, I have to do one last thing. Because we have half a paralegal and a full attorney.
Well, that's okay, right?
I think you should have a full paralegal and half an attorney.
Probably so. Okay.
All right.
Seconds of silence.
Okay, that was
Okay.
silence. So, any questions?
I have a question here. So anyway, we talked a little bit about fees here. Now, do we flat fee these things?
No.
Okay. So maybe this would be something you could help, because obviously fees are always kind of an issue. Have any suggestions about how you could keep the fees down, and what are the typical things that might drive fees up?
Sure. No, absolutely. So the first thing I'll start out by saying is Steve brings up a good point. We don't flat fee these cases, and what we mean there is we're not going to just charge you a set amount regardless of what work is involved. We do charge hourly for the work that we do with regards to these cases. So that means that as we're working, Teri and I are both keeping very close track of our time. We bill you in 6-minute increments, as most lawyers do, or tenths of an hour. And so the first thing I will say is, as the attorney, my billing rate is obviously higher than the paralegals. And so whenever you have questions or things that you want to address with us, I always recommend that you call and talk to Teri first, or send Teri an email and let her respond to your questions. If it's something that is really legal and she feels that she needs to have me address it, then she'll bring it to me, but let us make that call. Always go to the least expensive person in the office first. And that's not a comment on the quality of your work, it's just, unfortunately, that's what the courts let us charge. The other thing that oftentimes does drive up the fees, or one of the things that drives up the fees, Teri mentioned earlier, and that's the capacity declaration. That's the document that has to be filed or filled out by the physician or psychiatrist or psychologist. And as we mentioned, if you can marshal that through that process for us and then provide it back to us, that really does save you some money on the fee end. The other things that drive up fees sometimes are just, if it takes a long time for people to respond to us, if Teri's got questions while she's drafting and she reaches out to you for more information, if she has to wait for, days and then has to follow up with you and ask the question again, each time she sends you an email or gives you a phone call, it's costing you money. So try and be really responsive when we reach out to you. The quicker you get the information back to us, the better it's going to be. It's more helpful for her, and it's going to be cheaper for you in the end. I can't think of anything else obvious. Do you have anything
No,
to
that's
add?
why filling out the capacity, or the conservatorship questionnaire thoroughly is very key. That will definitely keep your costs down.
Yeah, that's a really good point. Obviously, the more questions we have to ask, the more we have to reach out to you, the more expensive that process of drafting all of the paperwork is going to be. So the more information you can give us at the outset, the better, because then we hopefully will have a complete picture and be able to do a better job in putting all of that paperwork together. So,
Do we have any questions from the audience here, or apparently you've answered all of their questions. You did a very thorough
So
job.
either that or we put them to sleep.
I
I'm
know.
not sure which.
Okay.
Oh, look, question. Yes.
How about an example on every 2 years, there's a status report.
Yeah.
What's a typical average fee for that?
Yeah, that's a good question. So if it's just a straightforward, so, you know, Teri calls you and says, hey, your status report is coming due, and, you know, she emails you the report, you fill it out. If you, again, file it directly, then that's even less. Just that communication with Teri, that's just a few minutes, and I would guess, you know, you're looking at less than $100.
Oh,
Yeah. If we file it for you and serve it on everyone, then of course there's some time for that. So that would put the fee up closer to maybe $200. But you know, we're not talking about a lot of money, but you know, as you might imagine, we have clients that they get a bill for $35 and they're calling wanting to know why they got a bill. So we just want to be totally transparent and let you know that you are going to get charged for that sort of activity. Yeah.
for Alameda County, is that extra for that?
Alameda County is one of the counties
Yes.
that requires the general plan
Oh, good.
and the status report and another document called determination of level of care.
Thank you.
Yeah.
Yeah.
There are
So
county differences. Now we have a question from our YouTube listeners here. We have, if there's no conservator, can you prevent contracts with the power of attorney? So could you protect
No.
somebody from
Yeah.
being taken advantage of and entering into, like, for instance, the parent, you know, we've run into this. If somebody signs up for one magazine, now they're going to get 10 magazines, and they're going to 20 magazines, right?
Right. Yeah, unfortunately, a power of attorney, again, is just a voluntary document where an individual is granting a third party power to represent them for particular transactions. It's not taking away any of the individual's personal rights or abilities to make decisions for themselves. So in that circumstance, if they enter into a contract and they're not conserved, the contract is going to be presumed to be a valid contract and you're not going to be easily able to undo it. Whereas with a conservatorship, where their power to contract for themselves has been taken away from them, then if somebody is foolish enough to enter into a contract with them, you could immediately have the contract deemed null and void because the person entered into it without having that legal right to do that. Yes?
Are there areas where you see most commonly that a conservatorship, limited conservatorship, is more beneficial than, say, like a special needs trust or a medical directive or some of these other legal tools?
I don't really. I think, you know, assuming that the person has the capacity to enter into a valid power of attorney and a valid advanced health care directive, I think that those documents are just as effective in being able to continue to be involved in making decisions. Really, the only difference as far as the power that you as the agent would have is the possibility that the person could later revoke your power. Whereas with a conservatorship, they're not able to do that without the court agreeing to do that. They'd actually physically have to petition the court to terminate the power. Under a power of attorney or advance directive, of course, they voluntarily have given you the power so they can take it away. That's really the primary difference. But the scope of the powers are very similar.
So it really comes down to the capacity of the individual.
Yeah.
Have you seen situations where, you know, I'm going into this blind, I have no idea what the potential pitfalls are of limited conservatorship. What things have you seen that where maybe a limited conservatorship may have been a disadvantage to an individual, or may have caused maybe some harm where, you know, maybe some unintended consequences type of thing?
Right. I can't really think of an instance where it really caused direct harm in the sense of, you know, some bad consequence occurred. Maybe one, I would caution that if the conservator and the conservatee live in different school districts, this is one that did come up.
Oh, yes.
The district of where the conservator resides is the controlling school district. We did have a case with a special ed situation where the conservatee lived in one school district and the parent lived in a different, and there was a battle between the school districts as to who was going to provide special ed services. But that's about the only time I can think of where we really had kind of a legal quagmire that was caused by the conservatorship itself. I think just, other than that, it's just this consequence of someone's rights being taken away, and, that in itself is a consequence to the individual, and of course we don't want to do that unless it's truly the appropriate thing to do. I mean, I would hate to think that but I'm sure there are, unfortunately, families out there that do use conservatorship as a way of maybe controlling an individual that doesn't truly need to be controlled. We certainly are alert to that, and we won't represent families if we get even a hint of sense that that's what's happening. But
so we only represent good conservators.
Yeah, we only represent good families. Whatever that means. But yeah, I mean, because we don't want to be conserving someone where it's not the appropriate method. Yeah.
Here's a good question here. And by the way, Mark, you're asking excellent questions here. Can we be the representative payee for Social Security without being a conservator, but it's also saying without being the designated payee?
Well, so I can answer that, yeah. So yes, you absolutely can be the representative payee through Social Security for either Social Security Disability or SSI benefits. You do not need to be the conservator of the person in order to apply for and be granted that. I will say that being the conservator is helpful, and the Social Security Administration may ask if you are a conservator, and if you are, they'll ask you to provide them with a copy of the conservatorship papers, and that pretty much assures that you're going to get approved as the rep payee, but you don't need to have conservatorship in order to be appointed. And there's many families out there that have been appointed rep payee, and the individual's not conserved.
And I think, once again, trying to make more sense out of this question is asking, can we be the representative? Can we actually be the person who talks to Social Security without being the representative payee? And I think even a conservator, unless I'm wrong, you're still going to have to sign all the proper paperwork.
That is correct. The only person that can speak with Social Security other than the benefits recipient themselves is the representative payee. Social Security, because they're the federal government, they don't recognize powers of attorney, and they don't recognize conservatorships in the sense that they will not disclose information to you using either of those vehicles. You must be the representative payee in order to get the information about the individual's benefit status.
So if you give letters of conservatorship, they'll probably go, isn't that nice?
Right.
You still got to figure out
They're still going to tell you need to apply to become the representative payee before they'll give you any information.
Here's another one. Can I stop my daughter from having sex if I got a conservatorship, the power to have control over social and sexual contacts?
Well, legally the answer is yes. The court has given you the power to stop your daughter from having sex. On a practical level, I would say no, because I'm not really sure how you utilize that power effectively. If your daughter is vowed and determined to have sex, she's going to figure out a way to have sex. And it doesn't just work for daughters, it works for sons too. We actually have this conversation often with clients who are worried about this. And I don't mean to be flippant about it, but you have a piece of paper that a court has granted you a power, but how you actually utilize that power effectively is really a challenge sometimes. Kids are what kids are, whether they're disabled or not. They're going to do what they want to do, and they're going to find a way to do it, even if we as their parents say that they shouldn't do it. And so, that's just the practical reality of life, and you have to, you're going to have to continue to work with your child just like you would whether or not you had the conservatorship in place.
And I think it's fair to say that we've had some situations where this hasn't been a big issue. So if it is a big issue, that's something that they certainly want to talk to you and Teri about.
And we can certainly counsel people individually on that. And I do understand that for some individuals this is a very concerning issue for a variety of different reasons. It could be a medical issue. It could be bad judgment on someone's part. We have had clients that have gotten themselves into trouble in this area, and they're frankly difficult situations. And just because you have a legal authority to do something is not always necessarily the magic answer. It can be helpful, and I'm not saying not to request the power, but it's just one tool.
Great. Here's a tough one. Okay, what, if anything, can we do to protect someone against like TSA or similar agency outside the U.S. from separating and interrogating an individual with a disability? And I think it's fair to say that goes beyond the scope of this discussion, unless you have a bright idea.
I don't have a bright idea. But it does lead me to another topic, which I'll mention because it wasn't covered in our presentation, which is what happens when you're conserved in California and you are outside of the state of California. If it's a temporary sort of travel situation within the United States, the conservatorship is still going to continue to be recognized. We have laws within the U.S. where orders of courts from state to state are recognized throughout the country. So, you know, if you're in New York for a vacation and something comes up and you need to take so-and-so to the hospital, they're pretty much going to respect that you have a conservatorship in California, and they'll provide medical treatment and information to you. If you're outside the United States, probably not going to be quite so easy. You know, fortunately, we've never really had that issue come up. If the conservatee moves out of California and takes up residence in another state, then you have to reestablish conservatorship in the new state. So if you know that there's the likelihood that either the family is going to be moving or the conservatee is going to be moving, that's something that we would certainly take into consideration when we're meeting with you to decide whether it makes sense to go through the process here, spend the money and the time, if it's only going to be valid for a short time. Because unfortunately, these conservatorships are not portable from state to state. You do have to pretty much reestablish the conservatorship again in the state that you're going to. Now, I will tell you, fortunately, pretty much any other state you go to other than California, the process is going to be easier and probably a little less expensive. We have probably the most protective statutes across the country. So if you go through it here in California, you've probably gone through the worst, and it would only get easier from here, but you'd still have to reestablish it elsewhere.
And let me just make a comment for our YouTube listener that's got this question. I think for this here, since we're talking about developmental disabilities, if you're in California, I would have you call the ARC of California in Sacramento, and this would be the kind of thing that the ARC deals with. And also the ARC of the United States works on these kind of issues too. Our subject today is developmental disabilities, but if we're talking about somebody with a mental health diagnosis, then where we'd want to go is the National Alliance for Mental Illness in California, or the National Alliance for Mental Illness for the United States. Those would be the two organizations that would be the most helpful for that. And I would be more than happy to help guide this person. One is to protect your loved one, but the other thing is there's some policy issues involved in this as well. Anyway, we're getting to the end here. Any last
I was going to say, I saw one more hand up in the back.
Okay, thank you. Professional conservators, are they court appointed?
Yeah, any conservator must be court appointed. When you say professional conservators, there are people who, as their profession, will serve as conservator. Usually it's a conservator of the estate situation. Usually they come into play where there's money that needs to be managed. But yes, they still have to go through the same process that you as a parent are going through. They have to file all the same paperwork and be appointed by the court. Yeah. Okay.
Yeah, so, and then let's just go back to one thing as we try to wrap this up. You know, you had talked a little bit about co-conservators here and that sort of thing, as far as the advantage of having co-conservators. Here, is there anything else if you wanted to designate somebody as a successor conservator that you might want to do?
Okay. Unfortunately, there's no formal process under our probate codes that allow for successor conservators. So when we're going through this process, there's no way to say, if something happens to me, then Joe is going to step in and automatically become the conservator. The courts don't have a process for that, and the probate code doesn't allow for it. So that's why when we're working with clients, we often will suggest that we have a younger family member, usually a sibling, that joins as part of the application so that we have that person kind of in place to provide for transition. The other option that's available, well, there's really two. You can always go back to court later and add conservators. So if you have a situation where it doesn't make sense to have a third conservator with the parents now, but maybe in a few years it would, then we can go back and have a co-conservator added. It's a shorter process as far as there's not as much legal proceedings that are involved. We still have to go back to the court and file paperwork and go to a hearing, but it's not as difficult as the initial process. And then the other option would be that you can sign a document that's basically a nomination of conservator. So if you're acting as conservator now and you want to express to the court and to the world that if something happens to you, you would like somebody else to be the next conservator, you can make your wishes known. Just make sure that somebody knows that you've done that and where it is. And then we sometimes will go into court, petition for this new person to be appointed, and we present the nomination to the court. And that's pretty good evidence to the court that that's what they should do. I mean, it's pretty rare that they would not appoint the person that you've nominated as the successor.
Teri, for you, that's let's go back to noticing. What if you had a situation, let's say, with a parent who's never been involved, maybe was abusive? That happens on occasion, and this is somebody you really don't want to notice. Do you still have to notice?
Yes.
Unfortunately,
yes, you do.
The only exception to that would be if there's like a restraining order situation or something like that, or where I've seen once or twice where there were physical concerns about a person knowing information about the conservatee's whereabouts and things like that. Under those very unusual circumstances, we can do declarations to the court explaining that and asking that the court waive the notice requirement to the bad actor, for lack of a better term. But unless we have really extreme circumstances like that, we have to make every effort that we can to notice the immediate family members. Now, sometimes we have situations, and Teri can talk to this, where we don't know the whereabouts of family members, and there's a process for that too.
Mm-hmm.
You want to kind
And
of
again,
describe
that's a declaration to the court. We explain to the court what the situation is. And they're usually on board with waiving notice to that particular person.
But we do have to establish that we've done due diligence to find the person.
Yeah.
So we have to go online and run their name through various databases to try and locate a mailing address. Which sometimes, if they have a really unusual name, sometimes we actually find them. If it's a very common name like Joe Smith, well then, we run that and we're going to get a gazillion hits, and we're going to say there's no way for us to know which person it is. But we'd have to document all that. We have to reach out to other more remote family members to see if they know how to get a hold of this person. It does take some work. And again, that's something that's going to drive the fees up a bit, because that entails some extra work that we don't normally anticipate. So
I think it's really important because, of course, we want things to run as smoothly as we can, and this is one of the reasons why we can't flat fee these things, because some of these things are very easy, and sometimes when you're having a noticing issue, there's lots of time involved. So just make sure in the initial appointment with Jennifer and Teri that you let them know all these different issues, because we sure don't want surprises as we're going down through the process here.
right.
Here's something we just dealt with here. In the event that all the conservators pass away at the same time, does the document expire, or does the court appoint somebody?
Interesting. So a limited conservatorship, which is the type of conservatorship that we're talking about today, terminates upon the death of the conservator. If there's more than one conservator and they both die simultaneously or otherwise, then the conservatorship is considered terminated, and we'd have to go back in and reconserve the conservatee with a new conservator if that's the occurrence. It's not the end of the world, and sometimes it's just unavoidable. I mean, things happen that we can't predict, but that's another reason why it's good to do some kind of pre-planning, have that extra conservator in the mix if that's appropriate, or have somebody lined up, particularly as we're starting to age, keep in mind that adding a conservator at some point is probably a prudent thing to do rather than waiting until it's too late.
I think I'm sure there's other things we could talk about, but I want to thank you so much for this. And once again, this will be up on our website soon. And we will also make sure that the attendees and anybody who's watching this here on YouTube and our other channels, that we'll have a link where you can download the intake sheet, the PowerPoint, and that sort of thing here. So I want to thank you folks for all watching. The other thing is I want to suggest that you subscribe to our YouTube channel. We have a plethora of other programs coming up on all sorts of different fascinating subjects having to do with disability and the law here. And with that, I want to thank you so much. Here, I learned something today, so thank you.
Thanks.
Thanks.
Okay.